Welcome to Law Talk on News Talk 1230 and 1450 WENY. Email your questions to lawyer@betschitomer.com. Now, here's your host, Susan Betsch-Chitomer.
Good morning, everyone, and welcome to Law Talk. This morning we're going to talk about what not to do. I've just had a whole slew of cases lately where people have done things that, or not done things that they should have done. And I have an interesting situation in my own family. I had an aunt pass away, and I guess when we were little, she liked me a lot because she wanted to adopt me when I was little and my parents got divorced. My mother just said, no, thank you, I'll raise my child myself. They got divorced when I was like 5, so I don't know what she was thinking. But anyway, my aunt never had any children, so I suppose that's what she was thinking. And she wanted to adopt me. But after that, I didn't see much of her, you know, occasional holiday meal or whatever. I didn't see a lot of her. But she passed away recently. And she had a life partner, and they never got married. And I don't know why. It wasn't a marriage equality issue. They just never got married. They each had their own home. They bought a house together. And they both made wills, which is something I always advise people to do. Yay, they did the right thing. And they both had lawyers, so this couldn't have been an accident, all right? So they both left everything to each other, along with some specific bequests for children of his, because he had children. And then they didn't leave any residuary beneficiaries. So the way the wills were set up is that everything went to the other person, except for these few items like a boat and something else. And then there was a bequest my aunt made to the college she used to teach at. And then, but it was clear that unless they died in a common accident, you know, one of them was going to die before the others. So basically it was winner take all. So if he died first, her family got everything according to the rules of New York State intestacy, because a lot of the stuff in the will didn't have anyone named to take it. And if she died first, then everything went to his family. And like I said, they each had lawyers. They had 2 different lawyers, so this couldn't have been an oversight. I think they just didn't care. So it's like they wanted to make sure each other was taken care of, and what happened after both of them were dead, they didn't care. Well, what happened was my aunt won the race by 2 weeks. So he passed away. She was in a nursing home, not doing very well, and she didn't make another will. Although my understanding is someone, I won't mention any names, but someone tried to get her to a lawyer real quick to change her will, but it did not happen. So he passed away, so everything in his estate was left to her, and except for those few bequests, and then nobody probated his will or anything before then, and then she died 2 weeks later. So, yay, our side of the family won. So if this hadn't happened this way, I would have just, you know, said, oh, I'm sorry, Aunt Nancy died. You know, it's a sad thing, but, you know, we weren't particularly close as I got older. And, but now we're involved in litigation because obviously his side of the family, his family does not want to give everything that their father worked for all his life to total strangers who weren't particularly close to either one of them. But that's what's going to happen. I mean, there can be some litigation about it, but I'm going to be doing a summary judgment motion soon, and the law's the law, you know. And I'm sorry, and I am very confident that if things went the other way, they would not be offering us anything. They'd be saying, "Too bad, so sad." I consider this, you know, a blessing from above, so I'm happy. But we're litigating. So if they had another idea, they should have put this in the will. And I had one case like this in my own practice where I pointed out, I actually did both of the wills, and I pointed out to them, you know, your family's going to be fighting over this after you're both gone, because, you know, this is not the way you're supposed to do things. And I made a note in my file that I had warned them about this in case anybody wanted to sue the lawyer for malpractice. Because I warned them, I told them, and their answer was, well, you know, our families haven't paid a whole lot of attention to us while we're alive, so let them pay a whole lot of attention to us when we're dead.
Wow.
Yeah. So they actually knew they were setting this up to happen, and they didn't care. So listen to the nice lawyer, and you have to have, it's a standard clause in every will. It's called the residuary clause. And you should also have backup heirs, because sometimes tragedies happen, not just because you're amused at the thought of people fighting over your stuff when you die, but sometimes there are tragedies. People you leave things to may no longer be with us. So you need to do a backup. And I usually do backups to the backups. The same thing with executors. You might name an executor in your will, and some people think they named their executor, and that's that. You know, you've named your executor, so you're good to go. But the executor can decline. It's a big job. It's a lot of responsibility. There's some liability involved if you do things wrong. So people sometimes decline the honor. And I had a case one time where I had done a will for someone, and we had an executor, and she said, oh, yes, you know, I'll be happy to do this, and I'll raise your daughter, and all this other stuff. And the woman was dying. So her friend assured her she would take care of everything. We did the will for the friend to take care of everything. And then the inevitable happened. She passed because she was terminally ill. I called the friend, and the friend said, oh, I don't want to do any of that. And I said, you told me and you told her that you were going to raise her daughter and that you were going to be the executor of her will. She said, oh, I just said that to make her feel better while she was dying. I don't really want to do any of that. And she could decline. I mean, people don't have to raise your children. They don't have to be the executor of your will. And I was just stunned that someone would do that to someone who was dying, you know. And while it's true that my client died with peace of mind, thinking everything was okay before she passed, things were not okay. So I'm not saying your friends or family would do this to you, but they could be too ill to take on the responsibilities. They could die first, or they could just be trying to make you feel better when you're dying. So, and I don't think this lady meant harm. I think she really meant well, but she didn't do it. And so what happened was that the person who ended up raising her child was someone my client didn't really like, and this is why she was so careful to make her will before she died, because she knew that otherwise this other person would wind up raising her child. And that's what happened. So always put backups to your backups. Another thing you want to do with your will is leave a list. If you have specific bequests, and even if they're long, some attorneys don't like to do lists of things. They just say, oh, leave it to the executor at their discretion and write a letter to the executor. Well, that has no power at all. If the executor decides to give all of the things to their favorite child, there's nothing anyone can do about it under the law. Whereas if it's in the will, you can enforce it. So we always do, if there's a long list, we always do an attachment and say, I want my property that's listed in attachment A to be distributed as an attachment A, and we staple it right to the will. And then when you're done with your will, when you've signed it and everything that has happened that's supposed to have happened, you go file it with the surrogate's court in other states that call different things, but you file it with the court for safekeeping so that nobody's running around looking for your will when you die, and so that no one can tear it up if they don't like what it says. And there are cases I've had where I'm sure that's what's happened. I mean, we can't prove it, but you know, Grandpa always kept his will in the top left drawer of his desk, but then somebody who wasn't left a whole lot got to the house first, and no one can find the will. So then it goes under New York state intestacy law, which means the person who wasn't going to get a whole lot gets a whole lot. So you want to make sure that you file your will properly with the courts. It's not legally required for you to do that, but it costs, I think, $10 as a $10 filing fee. Go do that. It's great insurance to make sure that your will is where it's supposed to be. The other thing it does, I have my clients, I'm across the street from the place, my office, where you go ahead and file it. So I have my clients, even if they're very frail elderly, I have them go across the street and file it themselves. Because no one can say you didn't know what you were doing when you signed your will. If you personally walk into the surrogate's court and say, here, this is my will, I want you to keep it safe, and pay the $10. Nobody's going to be able to say Grandma or Grandpa didn't know what they were doing, because the surrogate's court staff, in effect, becomes your witness. Because if you bring a will in, you knew it was your will. If you knew what court it was going to be probated in, you knew it was your will. So to the extent possible, I have them go in preferably by themselves, so it's clear that there's no undue influence there. And people go file their own wills. So again, backup executors, backup people to inherit things. If you say, well, you know, I really want everything to go to person X and I don't have a person Y, well, then leave it to your favorite charity as the residuary. I mean, there must be some cause you believe in on this planet somewhere. So make sure that you say where things go so that people don't wind up in court fighting about where things go and your money goes to people, or your things go to people who either won't appreciate it or you weren't close to. That's not a good thing. So you want to make sure that you do that. So the thing to do is not to get the will off the internet. I know, it sounds like I'm plugging lawyers, and I am. But the reason why lawyers get paid what we do is that we don't cost money, we save money. I mean, litigation I know of one estate that has actually gone bankrupt. There was over $100,000 in the estate. The lawyer's fees are now over that amount of money that was in the estate. So the estate is filing for bankruptcy. So none of the family's going to get anything. The lawyers are going to get a share, and any other creditors of the estate are going to get a share, and these people are going to get nothing. And I was in the courtroom when the judge was admonishing them, a couple of years ago, if you keep fighting like this, there's going to be nothing left of the estate, and none of you are going to get anything. And sure enough, that's what happened. So it's time for a break.
We'll be right back with Law Talk.
So Miss Hannah's with me this morning. Say hi. Taking her to work shortly. Hi, Rich. Hi, Stefan. Who else is here? Hi, Lori. Hi, Tamara.
Paint matching. Their experience and
Okay.
expertise are here for you spring, summer, winter, or fall. Trust Nappies to do it all at 3145 Lake Road Horseheads.
We all make promises.
So we're done with wills. We'll be talking about arrests and custody, divorce, things like that. Things you should not do. Real estate. We've got to talk about real estate too. That's a big one that's come up lately. I don't know why I've gotten several cases lately with real estate. I have people think they're selling real estate, but they have no written contract, or the contract is written so poorly you can't enforce it because they save money on lawyers. So until it's time to. Rich says hi.
Just about to go back on.
Okay.
Tomorrow, partly sunny, thunderstorm possible, high 86. After the 4th of July, chance for thunderstorms, high 89. For my complete 420 forecast, watch WENY News. I'm meteorologist Joe Barris for 1230, 1450 AM and 106.9 FM, WENY.
Do you have law questions? Email now. lawyer@betsjatomer.com. That's lawyer@BETZJITOMIR.com. Now back to
Okay, so we're back here with Law Talk, and we're going to talk about things that you should not do. And we'll move right into real estate now. We've already talked about wills and estates and all the things you shouldn't do there. Now we're going to talk about real estate, and then we'll move on to some other things like criminal law and family law. In real estate, one of the things that I've seen lately, and I've just gotten a whole handful of cases, and I'm not sure why, but people thought they were buying a house or land, and I say thought they were buying because they didn't have a contract in writing. So if you're going to buy real estate, you want to have the contract in writing because the law in New York, and indeed in most states, says there's no such thing as an oral contract for real estate. So in other words, even if it's your mother, father, sister, brother, best friend, have that in writing. And it's really best to have a lawyer do it. It's not very expensive to have us do a contract. What happens if you have no contract in writing? Then you may have no contract, and you may have paid on a house for years and years, and then you don't get it because the other side claims you're only renting. And so what can you do? Well, let's say you're in a situation like that, and you have what you believe is a land contract, but you don't have anything in writing. Well, one thing to do is to go to the other person and say, I really want to memorialize this in writing in case something happens to you, or, when the time comes that it's time to turn it over. We both know what it is. And you can get amortization schedules on the internet. So say you paid $50,000 for a place, that was the agreed purchase price, and you've been paying $500 a month for however long. There are free sites on the internet that will figure it out for you, that will print up how much you've already done with the interest rate and everything else. Figure out how much you've already paid, figure out how much you have left to pay, figure out the exact date that you'll have paid everything that you owe. One case I had, the man overpaid by $10,000 because they just weren't sure when it stopped. So we got him his $10,000 back, but not the interest or anything else on it, because it was his fault for overpaying. He didn't keep track. There wasn't anything in writing. Now the fact was the former owner, acknowledged, that there was a contract and they had some things in writing. So it wasn't a question of whether or not he was going to get his property. It was a question of whether or not he was going to get his overpayment back and whether he got it back with interest. So there's all kinds of things that can come up if you have a contract for land and it's not in writing. And it's so simple for an attorney to do it right. It's one of the most basic things that we do. So a lot of attorneys that aren't litigators, they'll do real estate and wills and things like that. And I do that too because, that's the easy work, and I do it ancillary for other clients that, if they're getting divorced, they need a new will, whatever. But these things are so easy to do right for attorneys. They're not very expensive. For goodness sake, get it done right and get an attorney to do it for you. So a proper contract for the purchase of property will have who the people are, how much money it is, exactly what it is that you're selling. We've also had cases where there's house and it's on, and they often do this in farms for whatever reason, either because they bought it piecemeal or something. And so are you buying the house and the 2 acres it's sitting on, or are you buying the house and the 200 acres that we call the farm? So if you just say, we're buying the property located at whatever, well, that could be the house and 2 acres and not the other 198 acres. So you really have to be specific. And sometimes when people are buying it, they don't know because they weren't born yet, or because, it was inherited by their parents from grandma and grandpa, and they don't know that there's several parcels of property. So you have to say, the entire 200 acres if that's what you're selling. Other words, if you just say the address, you're going to be getting the house and 2 acres if it goes to court, because that's all that's specified, and they always do it more narrowly than broadly. So you really need to be specific about what it is that you're buying and how you're buying it and what the interest rate is and everything else. So I've got another case where, I've had several cases actually, where people think they're buying property and there's nothing in writing because they trust the person for whatever reason. And then it comes time when they think the house or property should be signed over to them, and they're like, no, you're just renting. You didn't really buy that. And there's nothing in writing. And so what I tell people to do in that situation, say you're halfway through a contract and you go and you try to get them to sign a contract, and your oral contract, you're halfway through your oral contract, which will not stand up in court for real estate, the sale of real estate. So they won't sign anything. They're like, no, you can trust me, it'll be fine, I'm not signing anything, and you can't make them. So what you need to do then is, and please, for goodness sake, make sure that you're paying by cash or money order the whole time anyway, just to prove that you even made the payments. But on the memo line, say, in the memo line, payment on mortgage. Now, that's not gold, but it's better than the nothing you have. And then you can say, well, this is my 32nd payment on the mortgage, or 32nd payment of 70 owed on the mortgage. Put something in the memo line that indicates that you have a mortgage. And then at least a lawyer like me can go into court and make the straight-faced argument that because that's what the memo line said and they went in and cashed it, that they were accepting those terms and conditions and agreeing that's what that payment was for. The judge may or may not buy it because the person can say, no, they just owed me rent and I didn't notice what was in the memo line or whatever. People lie. And it's very difficult. It's way difficult to prove people are lying. And so I had a district attorney once tell me, Susan, if you can prove someone committed perjury in court, I'll prosecute it. But the fact is the rules of evidence are very strict, and you have to prove they knew they were lying. And that's very hard to do because you have to get in someone's head, or you have to have contradictory written evidence, an email, a text, or something. And a lot of times people will say, oh, well, someone sent me an email and, but I deleted it. Can't you subpoena it from Yahoo? Well, no, probably not. I mean, I could send them a subpoena, but, that's, first of all, it's more complicated than you might think. And second, they don't keep everything and they're not obligated to look for everything, and you might have to pay for them to try to find it, and it's often not findable, especially if you don't know the date it was sent. Well, sometime in the last 10 years. Well, good luck with that. So you need to be really careful with real estate. If you're buying real estate, get a contract and get it written up so that an attorney has described it. Again, I had another case years ago where there was a written contract and it had almost all the terms and conditions, but it wasn't clear what was being bought. So the person thought they were buying land on both sides of the road, but the way the contract was written, it wasn't clear that's what was happening. So at the end of the day, we managed to get most of the land that the person believed they bought, but not all of it because it wasn't properly described in the contract that they drew up themselves, all by themselves. And so you're not saving money by cutting the lawyers out. You're really setting yourself up for problems when you don't have an attorney draw up a contract for something like real estate. That is required to be in writing. And another thing that's required to be in writing to be enforceable is any contract that by its nature can't be done within 1 year. So if it's impossible to do the contract within 1 year, it has to be in writing to be enforceable. So, for example, if you're going to provide some kind of service or there's an employment contract and it's going to last for more than a year, then it's got to be in writing. Otherwise, you can't enforce it. And, employment contracts are hard to enforce anyway if the person wants to quit because, we have these rules against slavery. So. But if your unique skills, like if you're a movie star and you walk away from your contract, you can be stopped from making other movies, for the length of that contract. So they can't make you work for the one company, but they can stop you from working for others. So it's very complicated to have contracts that are oral when they're supposed to be in writing. Now, there's concepts called constructive trust. So someone can own property that's in someone else's name, and you know that you're holding it for them. But again, all the person has to do is say, I wasn't holding it for them, that's mine. And you're done, pretty much, because unless you have, again, something in writing that says, we're going to put this in my name because, for whatever reason. And often the whatever reason is something fraudulent, so the court's not going to help you anyway. So if you are putting everything in your name because you are trying to hide it from the IRS, you owe people money, you're trying to fool your ex-spouse into thinking that you don't have any assets or money, and therefore you're putting in someone else's name. Even if you put that in writing, because you're defrauding someone, the courts may not be so sympathetic to your problems. Okay, we're going to go take another break.
We'll be right back with Law Talk.
Today at Simmons, Rockwell Nissan in Horseheads and Hornell. Drive away in a new Nissan Murano lease for only $299 a month. A new 2019 all-wheel drive Nissan Murano S model with a 3.5 V6 engine, 18-inch alloys, forward collision warning, lease with no money down for $299 a month for 36 months. Only tax and DMV fees are due at signing. Shop Simmons-Rockwell.com.
The average time a resume spends on an HR manager's desk is 7 seconds, and most of them are tossed aside. Now imagine if one of those resumes...
Whatever, what, Rich?
I had to be resilient. That's something that you can't teach.
Or if that resume was from someone who...
Worked 12-hour shifts at the recycling company with my dad for 72. That taught me a work ethic that I carry with me every day.
We rely so much on a resume, yet it could never tell the full story of someone.
Growing up right here, a lot of things can got me away from the goals. But I learned to push through, and that's what I bring to work every day.
So maybe it's time we look beyond the resume and look to grads of life. Discover new ways to develop great talent that are so much more than what's on paper at gradsoflife.org. A public service announcement brought to you by Grads of Life and the...
Okay, I sent you that email about the case.
When I grow up, I want to be a new pair of blue jeans. When I grow up, I want to be a kid's first computer. One place on a day. Football skiing, bike that races around the country. I want to go on a forest trail. When I grow up, I don't want to be a piece of garbage. And if you recycle me, I won't be.
Give your garbage...
All right, 30 seconds.
Okay.
Learn how to I want to be recycled.
And you'll have about 7 minutes.
Okay.
As America's veterans face challenges, DAV is
Hello.
there.
My victory was getting my benefits and a good education.
DAV helps veterans of every generation get the benefits they've earned,
I'm a veteran. I didn't want to admit it, but I have PTSD.
so veterans can reach victories, great and small.
My victory was finding help and learning that I wasn't alone.
Support more victories for veterans. Go to DAV.org.
Hey, Kevin.
Now back to Law Talk with Susan Betz-Jitomer on News Talk 1230 and 1450 WEN.
And we're back with Law Talk, and we're talking about things that you shouldn't do, and we're in the final segment here today. So I want to talk about what you shouldn't do when you get arrested. Now, I want to talk about the presumption that any drugs or guns or anything else that's illegal in a car is essentially the property of everyone in the car. So they can presume and arrest everyone in the car. And that doesn't always go well for people. Sometimes it does. Sometimes someone will admit, no, it's really their drugs or their gun. But if someone, say, in the front seat throws the drugs or guns under the front seat, it's considered within the zone of control of really everyone in the car, because anyone can reach under that seat and have placed it there. So there's a presumption that if you're in a car and there's something illegal in the car, you all get arrested. And so I'm not saying that the police arrest people that they know perfectly well aren't involved, but let's just say you'll get arrested and it's legal. So what happens sometimes is you'll have a couple, and then one of them will feel compelled, because perhaps they have children, that they are going to admit that the product is all theirs, and so the other person can go home and take care of the kids. And so that's that's great to step up that way. Except now you've made my job difficult or impossible because you've admitted not only that you knew the drugs were there and that they were in the car, but that they're yours. So I'm an attorney, not a magician. So you really shouldn't talk, even though as painful as it is to see people get arrested. Wait until you all talk to lawyers, because when it's truly not someone's possession, often we can do something about that. Not always, though. So it's important for you to know whose car you're getting into, and you're not going to search the pockets of everyone in the car. And it's especially unfair when it's in the glove compartment, because if you sit as a passenger in someone's car, how often do you open up the glove compartment and rifle through it to see what's in there? Just so maybe you don't get in trouble. And that, in fact, would be considered rude. That's like going through someone's purse or something. You don't just go through someone's glove compartment. Yet, you will be held responsible as the passenger because the glove compartment is in your zone of control. So, be careful who you hang around with, seriously. And I've had people in my office who were in trouble like this saying, well, everyone smokes pot. Well, no, everyone doesn't. In fact, if you look at the statistics on the internet, you will find out that a majority of people don't. And some people find this really hard to believe because everyone they know does. But that's because people who don't hang around with y'all. So everyone you know does, because that's the only people who's going to hang around with you. So don't assume that just because everyone you know does something, that means everybody does it. And the police will hold you responsible for these things. And so you don't want to be getting in the car or hanging around with people who are going to get you in trouble. And especially if you know that like young ladies especially, and I'm sorry to put it this way, but sometimes men form groups, and women can too. I mean, we've had women gang members too, where they are involved in activities that they shouldn't be involved with, but you really like them, and so you hang around with them, and when they get arrested, you all get arrested. And you can wind up facing life in prison for something you personally didn't do. But if you ever facilitated whatever it is that they're doing, so you say, well, what does that mean? I wouldn't do anything to get someone murdered. Well, let's say it's a group of people selling drugs, and it's always got to be a group of people because they come from somewhere else, and then somebody has to sell them, and somebody has to deliver them, and so it's always a group of people. And let's say you loaned your phone to your significant other who's involved in the drug world. Well, you facilitated a drug sale. If they called someone and they made a drug sale, even if they just said, yeah, I'll meet you at McDonald's later, and you're like, no, he was just talking about meeting someone at McDonald's. Well, if he's meeting at McDonald's for the purposes of selling drugs, and you'd be surprised how often the police have this on video, then you facilitated that drug sale. So it's minor part, facilitating a drug sale, right? No. If that group of people killed anyone or robbed anyone, if you are in for a dime, you're in for $1. And I think that this is a bad policy in our country because it helps encourage people to maybe not be as forthcoming as they should be when they know bad things are going on. But you have to beware. You can't be involved at all with people like this, because if you give someone a ride somewhere and it turns out that it's a drug deal, and you're like, well, tell the police going to have video. I'm telling you, they spend enormous amounts of resources, sometimes for more than a decade, following people around, listening to their phone calls, searching all their emails. I know of one federal case in particular where I was one of the attorneys, one of the many attorneys. I think there were 52, that's 5 co-defendants involved in the case. And they were kicking down doors all over the world at the exact same time when they decided to put a stop to it. But there have been 2 murders by this group. And they were not recent either. So they literally let 2 people get away with murder knowing perfectly well who did it because they wanted to catch everyone in the drug cartel conspiracy. And so they did that. And everyone got swept up, including, and I'm using examples of one of the girlfriends who just loaned the phone and things like that, and she was facing life in prison. Now the prosecutor was reasonable, and she didn't get life in prison, but she got almost 2 years in a federal prison. So really, really, really don't hang around with bad guys. You'll regret it. So another thing that you shouldn't do when you get arrested or when there's a situation, is be rude to the police officer. Do not be rude to the police officer. You can decline to give any more information. You can say, I'm not going to say anything until I have an opportunity to talk to a lawyer. But be respectful. Do not be rude. Do not yell at them. Do not call them names. Don't hit them. Yes, that happens. Sometimes people are drunk and they, the police officer grabs them to put them in cuffs and the person reacts negatively because they're being grabbed. This is not a normal situation. This is a situation where if someone grabs you, you can't fight back. Otherwise, you get charged with assaulting an officer. So police officers are allowed to arrest you. They're allowed to put you in the back of the car. They're allowed to put handcuffs on you. And sometimes the handcuffs are a little tight, and if they are, then you need to be polite to the police officer and say, these are really tight, and I think they're cutting off my circulation. That's as tight as they'll undo them a little bit. But if they're just annoying tight, but your circulation is still going, they're going to be kept on that way. So Dr. Bitter is telling me, tell people don't talk at all. That's good advice. It is good advice, but it won't. People just don't do that. They run their mouths. All right, we're out of time. Frank is telling me we're out of time. So we'll see you next week on Law Talk. Bye-bye, everybody. People just don't do that. They run their mouths. All right, we're out of time. Okay. I'll see you all next week. Bye-bye.